Good morning, Europe. Good afternoon, Southeast Asia. Welcome to our webinar entitled How to Expand Your Geographical Indication to Southeast Asia and What's New. This webinar is brought to you by the Southeast Asia IPR SME Helpdesk. My name is Nora, and I will be today's webinar moderator. Joining me shortly will be Ester Olivas Cáceres, external expert of the Southeast Asia IPR SME Helpdesk. Sorry, I think my screen has not changed. So before we start with the webinar, let's make sure that we all have a good understanding how this webinar platform works. So we look forward to a lively discussion. So please type in any questions you may have during the webinar, and we will discuss it at the end. And then please also make sure that when we will be launching the poll questions, you will participate by selecting from the multiple choices answer. You can see the question box showing on the screen now. Okay. So let me quickly introduce you to the webinar agenda. So I will give you a very quick introduction to the Southeast Asia IPR SME Helpdesk services. After, Esther will move on with the presentation on geographical indication to Southeast Asia, what's new, and we will wrap up the webinar with a Q&A session. And then I will close the webinar with some quick information for you on our upcoming session and new publications. So the Southeast Asia IPR SME Helpdesk is an initiative of the European Commission to help small and medium-sized enterprises to protect and enforce their intellectual property rights in or relating to Southeast Asia. All our services are free of charge. So on this slide, you can see the wide range of services that we provide to companies. You can get in touch through the inquiry helpline, and we will reply to you within 3 working days to address your IP concern related to Southeast Asia. We also offer a wide range of publications on intellectual property rights related to Southeast Asian countries, and also we have industry-specific guides available online. We organize on-site trainings across Europe and across Southeast Asia, and we also offer online trainings like today's webinar. And we have some interactive learning tools, for example, e-learning modules that you can also access on our website and learn about IP in a funnier way, as you can test your IP knowledge with a quiz session at the end of the e-learning module. And without any further ado, I would like to introduce you to today's webinar speaker, Ester Olivas Cáceres. Ester is our, as I said earlier, external expert and also senior IP quality advisor for the IPR Helpdesk project with 22 years of experience on GI and IP related fields and working on multiple projects related to GI across the world. So now I would like to invite Esther and hand over the presentation to her. And Esther, you can share your screen. Let me know if that works.
Hello. I don't know, you let me know.
I can see your screen, Esther.
Yeah. Okay, perfect. Perfect. Okay, so thank you, Nora. Thank you for the introduction to the services of the Southeast Asia IPR SME Helpdesk. I hope you hear me okay. And also thank you for your nice introduction. Okay, thank you. So for your nice introduction to my background and current position, and also for organizing this webinar, which I hope will be useful for participants. Let me briefly, and I say briefly because I had some already some issues with the sound, but let me briefly share my camera so that you can see me. Hello. And I can welcome those who are joining us from Europe and America, and also for those who are joining us from Southeast Asia and Singapore, many other countries there in that region, and even Australia. So basically, I wanted you to put a face to my voice, but I will turn off the camera shortly after maybe introduction, like maybe giving you an introduction to the agenda of today's presentation. As you may know, this is a presentation that intends to go over the guide to geographical indications in Southeast Asia that I prepared over the past months with the support of the Southeast Asia GIs and Helpdesk and the supervision and guidance of the European Commission. This guide has been elaborated to provide a useful and practical overview of the legal landscape for the protection of geographical indications in the 10 countries of the Southeast Asia region. And today I will try to go over the most relevant aspects with you. As the guide is quite extensive, it won't be possible to maybe explain everything, but I really encourage you, as Nora mentioned, to type your questions on the question box available during the session, or even if any question comes up to your mind after the session, please feel free to refer them to the Southeast Asia GIs and Helpdesk, and I will be happy to give a response to you in due time. Basically, an additional thing I will try to do with you will be asking some questions during the session so that we can have an interactive, discourse and maybe do it more dynamic for you. So now that you have seen me enough of me now, I will turn off the camera and I will go and move forward if the system allows with the presentation. Okay, let's see if that passes on. Okay, so the first thing I wanted to do was introducing the GI concept. For those of you who are not familiar with what geographical indications, what we normally call GIs, are. Well, here you have this chart that tries to summarize the entire concept. So a GI is a sign that generally is a name of a geographical location, and this name of a specific place, region, or even a country sometimes is used to identify goods, usually products, which come from that specific place. This is the case of champagne, that I'm sure you know is a wine produced in the region in France of that name. So the name of the region is Champagne, or the case of Parmigiano Reggiano, which you also may know with the English translation Parmesan, to identify the famous cheese from that region in Italy that covers from the Apennines to the Po River. That name that is used to identify a product or products have a special differentiated quality, characteristics, and reputation that are due to its geographical origin. And this link between the quality and characteristics of the product and its geographical origin is built from the natural factors of the geographical area. Those can be the soil, the rain, the climate, for example, among others, biodiversity, for example, as well as from the natural factors. So the local know-how, traditional practices used to elaborate the product, which are often transferred across generations. This bond between the product and its origin builds up a reputation that can be local, regional, national, or even international. And I'm sure that you know cases like Colombia for its Café de Colombia, or Mexico for its famous spirit drink tequila. And it gives differentiated value to products with long history, therefore conferring GI recognition to products that already exist. I have already mentioned some, but I could mention many other examples of worldwide known GIs, like, for example, Bordeaux for wine from France, argan oil from Morocco, rum from Guatemala, Longines tea from China, or Irish whiskey from Ireland, to mention just some of them. You can see here some logos of European GIs, as well as some of GIs from Southeast Asia. After this introduction to the concept, I already would like you to work with me a little bit, and I would like to ask you a question. So let's see here. Here you have. So the question, I would like you to respond, as Nora explained to you, is, in your opinion, what is the purpose of a GI? A geographical indication is a legal tool of protection, so an intellectual property right. B, a differentiation tool of an origin-based product. C, a development tool for GI stakeholders to thrive. D, an economic and marketing tool in the market. Or E, a political tool to promote and protect local heritage. I think you will have a few, exactly,
yes,
you have a few seconds, no, to respond.
Yes, let's give a few seconds for the participants. I see we are receiving some answers, so I encourage those who have not yet replied to select one of the options, and then Esther will comment and we can discuss it. Okay, so I think we can share the result now. So Esther, please help to comment on the result. So we see that most of the participants have voted for legal tool of protection, via protection. What do you think?
Well, it's very interesting to see how most of you think that is indeed an IPR, which of course you're right. And this is a little bit a tricky question because in fact, as you will see now, all these purposes are correct. So it is on one side a legal tool, so an intellectual property right, which is used to protect the geographical name of a certain product from anyone that may try to use such name for products that are not the original one. So they cause damages to the real product and its producers, they affect the reputation of the product, and they mislead consumers about the true origin of the product. But the GIs are also a differentiation and development tool to distinguish a product from similar products in the market. So they give producers the opportunity to obtain better prices for their products, but also provides quality assurance to consumers, as well as a transparent information on the true origin of the product. Hence, it implies the existence of a community of producers and processors, which are the GI stakeholders, helping them to progress and develop, so to thrive. It is also an economic tool, as well as a marketing and sales tool for competing in existing and new markets and encouraging visibility and promotion of a product. And at last, it's also a political tool, whereas a collective action of the stakeholders of a GI may raise awareness and foster the promotion and protection of local, regional, and national heritage, the know-how and the reputation of the product. So in fact, this multi-purpose of GIs have resulted in more and more countries worldwide protecting the names of their products as geographical indications, because GIs are certainly an increasingly considered valuable intellectual property right. And that has also been the case in the 10 countries of the Southeast Asia region. Over the past years, most countries in Southeast Asia have established national legal frameworks to recognize and protect GIs, with an increasing number of local quality products identified and protected as geographical indications in countries like Cambodia, Indonesia, Malaysia, Thailand, and Vietnam. Such is the case, to produce some examples, of Kampot pepper from Cambodia, Buon Ma Thuot coffee from Vietnam, Saba tea from Malaysia, or Lampung Brokat Thai silk from Thailand. This recognition of high quality products has also brought along an increasing interest of today's Southeast Asia consumers in GIs from overseas. And that opens up a wide range of attractive opportunities for European GIs in Southeast Asia markets, as European products are generally considered to be of high quality. The first difference that we find between the EU GI legal system and the system in Southeast Asia countries regards the scope of protection. So what can and cannot be protected as a GI? Countries like Thailand, Malaysia, or Singapore foresee under legislation that a wide range of goods are eligible to be protected as GIs, so comprising agricultural products all the ones that you see here, foodstuffs, wines and spirits, as well as handicraft and industrial products. Conversely, Vietnam, Indonesia, Cambodia, and Laos, they remain silent on the matter in their legislation, but they do not include any restriction on the GI scope either, meaning that any kind of products can be protected as GIs in these countries. As a result, you see here a wide range of pictures and references to products, so processed and fresh meat, fresh fish, fruits and vegetables, dairy products like cheeses, beers even, spices, wines and spirits, as well as handicraft and industrial products. They can all be recognized and protected as GIs in Southeast Asia. Differently, the European Union also foresees the protection of GIs for agricultural products such as wines, spirits, aromatized wines, agricultural products, and foodstuffs. But non-agricultural products such as handicraft and industrial products cannot be protected as GIs at EU level. They can, though, enjoy protection as GIs at national level in certain EU countries through their national legislation, or they can be protected as collective or certification marks at EU level or at national level in a European member state. So again, after seeing all these types of products that can be protected as GIs, I would like to ask you another question. Do you think that a European product's name can be protected as a GI in Southeast Asia? And here I offer you several possible answers. A, yes, if it identifies food, wines, spirits, or handicrafts. B, yes, but only if it identifies food, wines, or spirits. C, yes, as long as it is protected in the EU. D, no, because only Southeast Asia GIs can be protected in Southeast Asia. Or E, yes, but only in Southeast Asia countries that allow protection of foreign GIs. So we will give you again a few seconds to respond.
Mm-hmm.
So this poll will help me to have a general idea of your knowledge about the GI landscape in Southeast Asia, if you are more or less familiar with the scenario, if you already have experience in the area.
I think we can launch the result now. We received the feedback. So for this time, most of the participants said only in countries that allow protection for foreign GIs. What do you think,
Okay.
Esther?
Well, first of all, thank you all for participating. It's nice to have your feedback, and it's interesting to see how you think that it is only in countries. In a way, that could be correct. The fact is that, as you will see here, the answer is yes. Yes, European GIs can be protected in Southeast Asia, but there are key aspects that you need to bear in mind. So basically two. One is that there is no common legal framework at Southeast Asia level. So there is no regional framework that covers the 10 countries, but there are different systems in each Southeast Asia country. Okay, so in countries like Cambodia, Indonesia, Laos, Malaysia, Singapore, Thailand, Vietnam, and hopefully soon Myanmar, where it is still to be implemented, you can protect your GI as such, because they all have what is called a sui generis system for GI protection, which is a special regime for GI protection. And that is also the system that is used in the European Union. In other countries, though, like the Philippines, Brunei, and Myanmar for now, you can protect your GI as a collective or certification mark, similar to what happens in countries like the United States of America. And in some countries, it's even possible to combine both systems of protection, which means that products can be protected as GIs, but they can also be registered as collective or certification marks. That is what happens, for example, in Vietnam. Furthermore, all Southeast Asia countries, they come with other legal remedies for the repression of unfair competition or for actions of those who try to mislead consumers with products that are not the authentic product, what is called the passing off actions. But often, these systems, they can be challenging to demonstrate the legitimate GI right or the damages resulting from that unauthorized use. European GIs, they can also be protected if the EU has a bilateral or regional agreement with an ASEAN country that includes the protection of those GIs. That is the case, for example, of the free trade agreements between the EU and Singapore and between the EU and Vietnam, which are currently under implementation, or the free trade agreement between the EU and Indonesia that is being negotiated at present. They all include chapters for the protection of GIs. I encourage you to consult anyway the guides to geographical indications in Southeast Asia to get more detail on each of these systems and what are they about, specificities, and you will have all the reference to the countries that have one or the other system. But the other aspect to bear in mind, what they all have in common, and it is very important requirement for you to remember that applies to most, if not all, countries around the world, is that in order to register your GI in Southeast Asia, this GI must also be protected in its country of origin. That means that a European GI shall be protected in the EU in order to apply for registration in Southeast Asia. So should EU GIs be protected in Southeast Asia? Well, I strongly recommend you to do so, because despite the fact that most Southeast Asia countries have progressively built good laws and regulation, IP infringements are still relatively common throughout the region. And in the case of GIs, the increasing interest of consumers in quality products linked to the specific origin inspires free riders to unlawfully label other products using GI names. Therefore, by protecting your GI, you can more effectively take measures against those who use your GI without your permission, seeking to benefit from your reputation. However, before deciding how to move forward, it is important for you to bear in mind several aspects. I would say you should ensure that your GI is protected in the country of origin. As I mentioned, it must be protected in the country of origin before being protected in Southeast Asia. You should assess the means of protection available in the country in which you want to protect your GI. If it is a sui generis system, if it can be protected, they can be protected as collective or certification marks. And that way you should gather all the information relating the requirements, the procedures, the costs. You should also undertake research to rule out possible conflicts between GIs and prior rights, because you might face challenges if prior rights on your GI are already registered by third parties. And you should examine the protection system that is best adapted to your needs, not only in terms of compliance with national requirements, but also regarding the level of protection and IPR enforcement available. And you may think, how do I do all this? Well, my recommendation is to seek the advice of local intellectual property experts in order to assess the best GI protection options in the target country, as well as to assist you on the registration procedure. Here, I would like to share with you the first case study or experience of a EU on GI protection. And that study relates to the GI of Champagne that I already referred. As I mentioned, and I'm sure that you all know Champagne because it's an excellent GI, worldwide known, is a wine exclusively produced from grapes grown, harvested, and processed into wine within the geographical area of the Champagne region in France. Hence, only the wine produced in that specific territory and complying with the product specifications of the GI may be called Champagne. Champagne has been registered in the European Union as a GI since 1973. And of course, as I'm sure you know, it's recognized and appreciated worldwide. And for that same reason, it is often subject to imitation, evocation, and in summary, infringements from free riders seeking to take advantage of this consolidated reputation. That is why the Comité Interprofessionnel du Vin de Champagne, also called Comité Champagne, which is the trade association that represents the interest of champagne producers and champagne houses, has a protection policy in place operating through a global network of bureaus in 16 of the biggest export markets for champagne. Their job is to protect the image of Champagne within the respective market and to report any misuse of the name. So regarding the Southeast Asia region, the Comité Champagne has been taking a leading role in protecting the GI Champagne, taking into account its increasing presence. I have to say that in 2019 alone, Champagne was shipped to all Southeast Asia countries except for Brunei, with a total volume of almost 2.5 million bottles and a value of almost 53 million euro. So as you see, the presence in the region is very important. And the growing interest in Champagne by the countries of Southeast Asia represents a promising future for the export of the GI, but also implies the possibility of having to face infringements by third parties. In order to prevent this misuse of the name Champagne, the Comité Champagne has committedly worked to ensure the protection of the GI through the registration in countries like Indonesia, Malaysia, Myanmar, and Thailand, through bilateral agreements in Singapore and Vietnam, and through the common law in Brunei and the Philippines. So along the past year, 2019, the Comité Champagne furthermore received the registration certificate for the GI Champagne in Laos and in Cambodia, completing thereby the protection of the GI Champagne in all 10 countries of the Southeast Asia region. So it is also important to note that as a sign of this strong engagement of the Comité Champagne, they have at present protected the Champagne GI in 121 countries around the world within the framework of legal registration systems or bilateral or multilateral agreements on GI, so including the 10 countries of the Southeast Asia region. What are the lessons that we can learn from this experience? Well, I think it is very important to undertake a prior assessment of the export potential of the GI as well as on the means of protection available in the target markets. It is highly recommended also to look for protection through registration in the market where you want to export your GI, and registering your GI will always provide you with a powerful tool to take action against possible infringements. So how can European GIs be protected in Southeast Asia? As I mentioned, we cannot go over the entire guide, but the guide to geographical indications in Southeast Asia will give you further details. So I'm going to raise the most relevant aspects on it, and then I will just encourage you to consult the guide for further information. So who can apply for registration of a GI? Well, in those countries with their own GI sui generis system, remember, those are Cambodia, Indonesia, Laos, Malaysia, Singapore, Thailand, and Vietnam, and hopefully soon Myanmar, the applicant will usually be a group of producers and or operators, an association or organization, an institution representing the community, but we can also see local authorities, groups of consumers or interested parties, or even only one producer from the geographical area as GI applicants. For those countries where GIs are protected as collective or certification marks, such as Brunei, the Philippines, and also Singapore and Vietnam, if you choose to register the GI as a collective or certification mark, the applicant will be a GI association or a GI certification body, in general, a corporate entity or a registered organization. As I said, please take a look to the guide for more specificities, because each country has its particularities and it's advisable for you to consult that. But one thing that almost all countries they have, except for Singapore and Thailand, where either is not required or it is not specified, you will always need an authorized representative. That is also called in some countries the agent or the proxy, to present your application. As all foreign applicants, they need a representative from the country, sometimes even a registered agent, to present their applications. What are the documents that are required to present your application to protect your GI? Well, here you have the most relevant ones. So in all countries, you will need to complete and submit an application form. In some countries will require the power of attorney or authorization letter, which in some cases like Cambodia shall be notarized. Except for Singapore, where only an address and the applicant's nationality is needed, all other Southeast Asia countries will require the identification of the applicant or the representative. As mentioned, and again, that is very important, please keep it in mind, you shall prove that your GI is protected or registered in its country of origin. Only in the countries where you register as a collective or certification mark, that requirement will not be needed. But all countries will require also documents to be translated and transliterated if needed in their respective official languages. For all countries registering names as GIs, the GI product specification, which is the key document, the technical document, what we call in French cahier de charge or disciplinare in Italian, or pliego de condiciones in Spanish, that document shall be presented also. And of course, another common requirement in any of the Southeast Asia countries is that you shall pay the prescribed fees, which are different from one country to another. In addition to those documents, other documents depending on the country may be a map, for example, maybe evidence of the right to register, maybe even a declaration of the actual use or intent of use of the mark. These other documents, they may be required depending on the country. That's the reason why I encourage you to consult the Guide to Geographical Indications in Southeast Asia to see the specific requirements in each of the Southeast Asia countries. How does it work? Let's see, the registration process. It is managed by the IP office in each country. So normally, what they will do is undertake first the formal or administrative examination in order to assess that you presented all the required information, the documents, the evidence. So the applicant or the representative, they have presented everything and everything is correct. And that will be followed by the substantive examination, which is a step to assess the legibility of the GI under the requirements and corresponding protection scope of the country. During that substantive examination, the GI application will be published for opposition. And in most cases, with sufficient evidence, any interested party may present an opposition or objection requesting the rejection of the application and the refusal of the registration. If no opposition is presented, or if it's being filed but it has not been successful, then the applicant complies with the requirements for protection, and the responsible authority will register the GI, record the relevant information in the official IP Gazette, publish the GI registration, and issue a GI registration certificate. In average, the entire duration of the registration process may last between 9 months up to 18 months, depending on the country, and also on the time that it might take to solve any opposition presented by third parties. So the time can vary from one country to the other, but also it will depend on the opposition or not against that registration. So after explaining to you the requirements, the applicant, the registration process, I would like you to, I know it's a lot of information to maybe process, but I would like you to respond to a question. That would be the last question, so I won't make you work anymore. So in your opinion, is the registration in Southeast Asia countries an interesting option for European GIs? And the possible answers would be A, yes, affordable and manageable by GI stakeholders. B, yes, but finding local IP experts may be difficult. C, no, it seems too complex to achieve. Or D, no, it is not worth the time and cost. So we'll give you a few seconds to respond. So of course, this is an open question just to gather your overall opinion on the application and registration procedure. If you find it feasible, and what are the challenges that you think a European GI may face along the process.
Okay, I think we can share the result for the third poll question and see how our audience thought about this question. So they are quite positive. Please, Esther, let us know what you think.
So I don't see the results myself. So can you tell them to me?
Yeah, sure. I don't know why. So 71% said yes, affordable and manageable by GI stakeholders. 29% said option B, yes, but finding local IP experts may be difficult, and no one has voted for C or D.
Okay, so that means that I'm very encouraging for you to register, and I haven't insisted enough, so I'm going to insist even more before I finish my presentation. So that is very good news. I'm very happy. However, I wanted to say, concerning the identification of local IP experts, it is important to know that some countries like Indonesia and Vietnam, they include on their websites a database of IP agents that you might need to use for representation and can also assist you in the process. So you may find the links of these databases on the guide to geographical indications in Southeast Asia. And also some European law firms, they have branches in Southeast Asia countries that can provide you with their assistance services. And it is important also to know that the Southeast Asia API SMEs Helpdesk can help you and provide you with further information and clarifications if you still have doubts or you need to know more about how to find an expert or how to tackle the procedure to register your GI in Southeast Asia. So just please feel free to take account of these options. But I would like to share with you one experience of a GI on registration. And here it is. It is the case of Parmigiano Rellano in Singapore. This is very recent, so it was at the beginning of 2020 that we had this decision. In fact, it's worth mentioning this case because, as I said, Parmigiano Rellano, which probably some of you know by its English translation Parmesan, it is a very well-known GI of a hard cheese that is only coming from the geographical area that comprises the territories of the province of Bologna to the west of the Reno River, Mantua to the east of the River Po, Modena, Parma, and Reggio in the Emilia region of Italy. So the name Parmigiano Rellano was registered as a GI in 1996, and ever since, stakeholders have joined forces with the Consorzio del Formaggio Parmigiano Rellano to protect and defend this unique product within Europe, but also in foreign markets. As a result, in 2010, Parmigiano Rellano was already registered as a GI in Indonesia and Malaysia, and as a collective trademark in Vietnam. In that same spirit, the Consortio applied to register the GI Parmigiano Rellano in Singapore since the register was created in April 2019 in compliance with the EU-Singapore Free Trade Agreement. The application was accepted and published for opposition, and someone, a third party, presented a request to extend the time to file the notice of opposition, stating that the opponent was recently made aware of the publication of the GI application, that the agent had just been appointed and needed more time to take instruction, and they needed time to prepare the evidence. So the opponent chose to proceed with the hearing and did not file the relevant documents before the opposition period concluded. At the hearing, the registrar considered that the presented arguments failed to show a good and sufficient reason for the extension based on several aspects. On one side, the list of EU GIs that had been published in 2013 already in the framework of the EU-Singapore Free Trade Agreement already included Parmigiano Rellano, so the opponent could have already seen since 2013 that that product was on that list. The opponent already participated in a public consultation, so he knew about the foreseeable registration of the GI Parmigiano Rellano. The registrar also stated that allowing an extension of time could delay the implementation of the EU-Singapore Free Trade Agreement, and also that the opponent had not provided any indications as to the basis of the proposed opposition. Even the opponent, according to the registrar, did not object to the applicant's GI per se, but to the name translated Parmesan. So the Singapore's GI legislation provides that objection to a possible translation of a GI is not a ground for refusal. Hence, the opposition would have failed even if allowed to proceed. So in light of all these factors, the registrar held that good and sufficient reason for the extension of time had not been established, and the request was refused. What are the lessons that we can learn from this case study? Well, I would say that, as you can see, GIs are still quite new and increasingly relevant in Southeast Asia. So seeking for protection through registration is highly advisable. The registration procedure will differ from one country to another, and therefore in some countries it's even starting its implementation, like in Singapore. So you will always need to be informed on the requirements to ensure that you present a complete application. And also you have to bear in mind that it is possible that third parties present opposition. Hence it's crucial to undertake a research in order to rule out possible conflicts with prior intellectual property rights, and to count with local IP experts in order to assist you during the entire preparation, presentation, and registration process. What are the benefits of protecting your GI? Well, the first one, I would say, it is that once your GI is registered, your protection, so that your GI is protected indefinitely as long as it is not cancelled or invalidated and the requirements of the GI remain. That is the case of a good number of countries, as you can see here. So Cambodia, Indonesia, Laos, Myanmar, Thailand, and Vietnam. Differently, when registered as a GI in Malaysia or Singapore, the protection has a duration of 10 years, but it can be renewed for further periods of 10 years, like it happens with the trademarks. And also in Brunei and the Philippines, where it can only be protected as a collective or certification mark, as well as in Vietnam and Singapore, if you choose to protect your GI as a collective or certification mark, the protection will last 10 years, and it's also possible to renew the registration for further periods of 10 years. So as you can see, that is one important benefit of protecting your GI, that the protection lasts either indefinitely or for 10 renewable years. But what is another aspect also very important and benefit from protecting your GI in Southeast Asia? Well, as I already mentioned, despite the improving systems for the protection of IP in Southeast Asia, unfortunately, infringements remain relatively common throughout the region. And the more your GI becomes appreciated and well known in a new country, the more you risk facing imitation or usurpation by third parties. So due to the territorial nature of IPR in ASEAN, to take action against these infringements, if you do not have your GI registered in a concerned country, may prove very difficult. That is the reason why protecting your GI through registration, it's always the first thing you should do, ideally even before entering the new market with your GI. How can you detect any abuse of your GI, and what can you do about it? Well, first of all, the first thing that I would recommend is to maintain a regular surveillance of your GI in the market. So that way you can take action through local authorities if any infringement is detected. So you should regularly maintain a survey to ensure that your GI maintains the reputation, quality, and characteristics so that it is sold in the same state in which it was registered, and that no one is using your GI unlawfully. Such surveillance will allow you to detect any possible abuse of the GI in the market. And you may wonder, how can I survey my GI in Southeast Asia and react against a possible infringement? Well, my advice would be first, to always set aside a budget for GI surveillance and enforcement when entering a new market in Southeast Asia. Seeking for professional advice to develop the best and more profitable strategy, as well as finding the right lawyer. As GI is a new subject in the region, it is also important to find the person that understands the GI right and has the relevant experience to achieve successful results in case of infringement. I think it will also be very important for you to bear in mind that you need to demonstrate your rights ideally through the registration in the country of origin and also in the concerned country, and also prove that the GI is infringed upon. So identify the infringement, collect evidence, and work proactively with local authorities to defend your rights. What are the options to take action? So if you identify an infringement, what do? Well, first of all, it's always advisable to explore the possibility to solve the infringement in an amicable way. So through negotiation or third-party mediation with the help of legal professionals. In fact, infringements in Southeast Asia countries may evoke or unlawfully use the name, thinking that they are maybe even flattering the owner. So it is important that with these negotiations, maybe you try to deal with it, and it may suffice to send a warning or cease and desist letter explaining the existence of a protected right through a GI and instructing the infringer to cease their activities so that you can stop that infringement. Likewise, also negotiation with local authorities can be useful, and in countries like Cambodia, Laos, Myanmar, and Singapore, private mediation to solve disputes seems to be a more viable option than going to court, which is generally expensive and more time-consuming. But if these amicable solutions do not work, then you have here several other avenues that you can use. For example, administrative actions. And you see here that they are available in Vietnam for small-scale infringements, in Cambodia and the Philippines. And the sanctions that may be imposed to infringers, they can be either a warning letter or fine. That would be a primary sanction, or additional sanctions as the confiscation or destruction of the infringing goods, or even other remedies like the removal or destruction of elements used mainly for producing or trading these goods, among several others. You also have civil enforcement that is available in all countries, but it seems to be more effective in countries like Brunei and Malaysia. Conversely, they are not so frequent in Vietnam because judges, they still don't know very much about GIs, or in the Philippines because it tends to be time-consuming and expensive. And it's also important to know that in countries like Vietnam, civil actions are possible in parallel or after administrative or criminal actions on the same infringements. You see here some of the sanctions that may be imposed to the infringer. Another option would be the criminal prosecution that is also available in all Southeast Asia countries. But it seems to be more effective in countries like Brunei, Indonesia, Malaysia, Myanmar, and Thailand. In Vietnam, these actions are foreseen, but not feasible in practice because they take too long and sometimes the results are inconsistent. And in Singapore, a criminal action would not result in the compensation for damages. Therefore, it's advisable to go for a civil action instead. Here you have also what are the sanctions that may be imposed to the infringer through criminal actions. And the last resource would be the customs control procedure, which is an action by customs authorities, which may be undertaken ex officio, so directly based on their criteria, or in response to a complaint raised by a GI holder. This procedure is also available in all Southeast Asia countries, and in some of them, like Myanmar, the Philippines, Thailand, and Vietnam, it is possible to voluntarily record your GI with customs to facilitate their work, identifying and blocking at the border any counterfeit good. You also have here the measures that may entail the customs control procedure, but it's important to say that it may be challenging for customs to identify infringing goods at borders, or may be ineffective or even not put in practice due to the lack of knowledge on GIs up to present. As I mentioned, is quite a new subject. Anyway, all these options are also on the guide to geographical indications in Southeast Asia. I encourage you to also refer to the guide for further information. And also you will have all the reference to the countries that tend to use more one system or the other. I would like, before I finish, to conclude with another case, and is also on Parmigiano Reggiano on their experience on enforcement. As I already explained to you, Parmigiano Reggiano is very well known, and they, of course, are subject to imitation, evocation, and infringements in many countries around the world. So they have to regularly survey their protection. So in 2016, the Parmigiano Reggiano Consortium toured the world, and they identified 3 infringements of the name Parmigiano Reggiano in Vietnam. So 3 applications for registration on the names Reggiano, the name Parmesan, which are the nominations already used by the consortium, are even the name Parmigiano Reggiano preceded by the name of the producer. The consortium took action against these identified infringements and presented opposition against their registration, based on their prior right of the collective mark registered in Vietnam in 2010. So please see how important it is to have it registered in the country. So Parmigiano Reggiano could raise that they had already been protected in 2010 as a collective mark in Vietnam. So luckily, the actions taken were extremely successful and allowed the consortium to stop the registration of these infringing applications. What are the lessons learned of this case? Well, I would say definitely that infringements of GIs can be, as you can see, a possibility in Southeast Asia region, as I said, because consumers, they are more and more interested in European GIs. Defining a strategy to regularly survey export markets for possible infringements is crucial so that you can detect abuses of your GI. Registering your GI will always provide you with a powerful tool to take action against infringement with local authorities. So you see how important it is to have your GI registered. And taking quick action against infringements, for example, in this case, presenting the opposition to an application, may avoid having to take more complex legal actions later. For example, imagine that these 3 applications would have succeeded and had been registered in Vietnam. Then it is more complicated to go to court to try to cancel the registration or even to react if they are using the names on the market. So again, I think that gives you an overview of the importance of protecting your GI in Southeast Asia countries, because that will be a powerful tool to react against any infringement. What are the conclusions, and this would be my last slide, that I would want you to keep in mind? Well, I think that these are the key messages that we can keep as a lesson from the entire overview in the Southeast Asia region. So first of all, GIs are quite new in Southeast Asia, but it is a fact that there is an increasing interest in EU high quality products. So it is a promising market opportunity for GIs. Registering your GI in Southeast Asia will always offer a safer option than accessing the region without any protection. Due to the territorial nature of IPR, you should assess the legal framework in each country to identify the protection system available. In order to register your GI, it will be important to prepare a complete application so that you comply with the requirements in the country. Seeking the advice of local IP experts will always be very useful for supporting you during the registration and during the enforcement if needed. Allocate a budget for regular surveillance of your GI in the market once it is registered would also be key. And taking immediate action if you detect any infringement of your GI will be very important. And for that, you will need to define a strategy and gather the maximum evidence to prove both your rights and the infringement that your GI is facing. And this is basically what I wanted to share with you today. So I know that my colleagues, they would like to maybe gather your questions if you have any, and I will be happy to respond to them. Thank you very much.
Thank you, Esther, for this insightful presentation. It was really, really informative. And I think that even if we have more in the GI guide that I will recommend to all our participants to have a look after the webinar. You managed to cover all important aspects, and we received some questions from the audience, so I would like to have the chance in the last few minutes to address those questions. So one question from Peter is, first of all, thanking the presentation to you, and he was asking if there is a time limit between obtaining the GI in the source country and when a GI application must be filed in other jurisdictions.
Jurisdictions within Southeast Asia?
This is not specified in the question. Let's consider Southeast Asia.
Okay. Well, there is no time limit as far as I know. I mean, you can file your application in several countries at a time. That is not a problem. But as I said, the most important thing is that your GI has to be protected in its country of origin. So let's think that you are talking about a GI from the EU, okay? It will have to be protected in the European Union, and then you can file your application in Singapore, Vietnam, Thailand, whatever you consider appropriate, and there is no need to wait for the registration in one country to proceed on the application with the other.
Okay, thank you. And another question from Sanas is, has been any case of opposition for an EU product, for example, an already registered certification or a collective mark?
It means in a Southeast Asia country?
Yes,
suppose, no?
We have not received this, how to say, yes, Southeast Asian country. Yeah, he just clarified it.
Okay. Well, as far as I know, not, but we have to take into account that you see in the negotiations of free trade agreements, as you may know, there are exchanges of lists. So there are European GIs on a list in the framework of the agreement, together with, in the case of Singapore or Vietnam, a list of local GIs also at the exchange. In that sense, we have to say that before they recognized the Free Trade Agreement Committee or Commission, they deal with the cases of possible, prior rights. So, for example, imagine that you were to go to a country where the name Champagne was already registered locally as a trademark or as a collective or certification mark from a third party that is not the original GI stakeholders. That would be tackled in the framework of the agreement with Singapore or Vietnam. But normally this is something that I strongly encourage you to do. So for example, if you are a stakeholder from a GI, you should, and there are many tools that you can access. I'm sure that we can provide you also with that support in the Southeast Asia BSMS Helpdesk with databases where you can find particularly in this case would be trademarks or collective or certification marks that may have been registered prior to your application. But of course, that will have to be spot. So you will have to prove that you have a prior right and that you have already a protection in your country of origin and that it distinguishes the product as a GI. However, it's something that in the worst case scenario will they will ask you to coexist. So coexist your right and the previously registered right. But normally what you have to do is to do a prior assessment first and then try to identify possible conflicts with prior rights. Normally they would be trademarks.
Okay, thank you. And one more question. We still have time for this question, and this would be the last question of today's webinar. Is there an initiative to have a harmonized regional framework of protecting GIs in Southeast Asia?
Well, yes. Well, I think they were negotiating at a time around, and don't take it literally, but I think it was around 2006 that they were exploring the possibility of having a regional agreement between the EU and Southeast Asia region. So this was the beginning of a possible regional agreement that would in a way harmonize the legal framework of all the Southeast Asia region. But as it happens with other areas in the world, that is not always feasible. As you will see in the guide to geographical indications in Southeast Asia, systems are very different. And the main difference is that some of them, like Brunei or the Philippines, they don't contemplate GIs as a sui generis system. They have it included in the trademark system. So in order to harmonize, I think that for now it would be challenging, but we have to say that these countries, Brunei and the Philippines, they are exploring to develop a sui generis system for GIs, which is an excellent initiative. And I think that would give room for exploring once more the possibility of having a regional framework. Is it happening in Africa, or is it happening in Mercosur? So areas where, or in the Caribbean, where they are already exploring to have a regional approach on GI protection. So for now, it is not there. It has been on the table, and I don't think it's a subject that is lost totally. So I am very optimistic and think that, we don't know, but maybe in the future we can see a regional approach for the GI protection in the region, in Southeast Asia region.
Thank you, Esther. I think it was a good question to close the webinar. And yes, for the participants, please take a look on the slide that we are showing now. This is the famous GI guide that has been drafted by Esther, and it gives you a comprehensive overview about geographical indications in Southeast Asia. So we recommend all of you to check it out. You can also download it from our website, and we will send it to you in the follow-up email. I also would like to mention that this webinar is recorded, and we will upload it to the website. So you will receive a follow-up email from us in the next 2 days, and you will be able to access the recording from that email as well. And on the current slide, you can see the upcoming webinars that we are doing at the end of June, beginning of July. So we will have a webinar on Lao. We will have a webinar on impacts of COVID-19 on IP protection in Southeast Asia, and another one also discussing China. And we will start July with a webinar on Myanmar. So I hope that some of you will sign up for upcoming sessions, and we were very happy to have you all for today's webinar. Thank you very much once again, Esther, for this insightful presentation. And
my pleasure. Thank you, Nora.
Yes, thank you. And I wish you all a good afternoon, good evening for those in Southeast Asia. And always feel free to reach out to the Helpdesk if you have any questions on IP. Goodbye.